Court of Appeals. I'm Judge Arnold Golden from Memphis, and joining me on the panel today is Judge Kenny Armstrong from Memphis and Judge Karma McGee from Savannah. As you know, each side will have half an hour to make their case. 15 minutes. And the appellant can reserve 5 minutes for rebuttal. You ready, Mr. Hivner?
Yes, Your Honor.
All right. Please call the case.
Tracy Darrell Adkins versus Rhonda Forlaw Adkins.
Good afternoon. My name is Russ Hellman representing. Good afternoon. Good afternoon.
I can't hear you too well, Mr. Hellman.
Okay, let's see if we can go. How is that, Judge?
That's better.
Yeah, thank you.
Thank you.
Good afternoon. My name is Russ Heldman, and along with Joni Abernathy, we're attorneys in Franklin, Tennessee. We represent Rhonda Adkins, the appellant in this matter, and we have asked Mr. Hivner to reserve 2 minutes for rebuttal.
All right, sir.
Good afternoon to all members of the Court of Appeals. This case is an appeal wherein we are asking the court for some basic relief, and that is if the court would reverse and vacate a decree of divorce incorporating a memorandum in order and parenting plan that was entered in January of 2017. We're also asking the Court of Appeals to vacate an order that was entered August 18, 2017, wherein the trial judge partially recused himself from one motion in the proceeding, and then the 3 other judges of the 21st Judicial District recused themselves also, and the matter was referred to another judge for determination of the motion that was pending. We're also asking the court to reverse an order that was entered on filed April 11, 2018, which awarded the husband a significant amount of over $500,000 in attorney's fees against the wife. And we're also asking the court to reverse and vacate an order that was entered on April 16, 2018, where the trial judge determined that he could have partially recused himself, and he did not have to completely recuse himself from the proceeding at the time that he did. Those are 5 orders that we're asking the court to reverse and vacate. Of course, later there was a motion an order denying a motion to alter or amend. But we're asking the court to vacate those orders, and it's important, I think, for me just to stay on the outset what I'm asking the court to do. We've raised a significant amount of issues on appeal. There's 17 issues cited in our brief, and I will not have time to go over each issue, but I'd like to address some that I think are significant involving issues of first impression, we believe, in this state, and hoping that the Court of Appeals will address these issues and resolve them favorably for our client. The first
Mr. Hellman, I have a question before you begin. It looks to me like you've got some piecemeal litigation going on here. You're asking the court to look at these orders, and you still have an ongoing divorce case that you submit you have outstanding issues in. In fact, your brief states that you still have outstanding issues.
Well,
is that correct?
We believe they are outstanding, but the lower court below, Judge McGee, entered a Rule 54.02 order. It's dated September 10th, I believe it was in 2018, directing that the orders listed therein, which were covered in my opening statement and some other orders, be deemed final for purposes of appeal. Now, I know that that is an important issue that the appellate court has to meet head on to determine if the court has jurisdiction to consider the appeal. Is that what Your Honor is asking me?
It is, Mr. Hellman. In fact, that order that you referenced that attempted to make orders final under 54.02, I believe, tried to make 14 orders final under 50.02, all in the context of that one order. but I believe your brief states that there are at least 40 orders on record in this file.
I believe there's approximately 40. Yes, ma'am. Now, we're right. Some of them were the interim orders that relating to various issues, but we are raising the main issue, whether the trial court erred in entering a decree that approves a marital dissolution agreement and parenting plan that we believe does not comply with aspects of the laws relating to the approval of marital dissolution agreements and the approval of parenting plans. We're also asking the court to vacate an order wherein he partially recuses himself from the case. And while the recusal was under advisement, the court later granted the attorney's fees, entered an order, took action in the case in April, and then after that, 5 days later, denied a motion for complete recusal. We believe that the Court of Appeals can address these issues. The trial judge entered an order making its order final, its attorney's fees order final. After that happened, the trial judge, we filed our notices of appeal. We also filed a motion under Rule 9 for the Court of Appeals, for the trial judge to certify the denial of complete recusal to the Court of Appeals. The court didn't address that issue because the court went on in a subsequent order to try to make them all final. While the case was pending, the court in 2018, the Court of Appeals issued 2 orders questioning whether the trial judge's order in April was a final judgment. After the Court of Appeals entered those orders, Ms. Abernathy and I filed a motion to certify the specific orders as final, taking the position that it was the intent of the trial judge to certify this case as final. I don't think Mr. Hayes, for husband, had any reason to oppose that they were final. And we entered the order. Later, I will say this, at some point in time, I think it was in 2019, we did file a motion asking the court to go in and determine whether it had appellate court jurisdiction. And if the court found that it did not have appellate court jurisdiction under Rule 54.02 and Trap 3, that it would do what I have seen done in another case, and that is the court finds that it should go in and take the case and deem it proper under Rule 9 for an appeal, or in the alternative, exercise its authority and jurisdiction under Trap 2 to go in and allow the appeal to proceed. We filed that motion, I believe it was sometime in the summer of 19 or late 19, and because we also wanted to go in and tether the issue before the court in case any of the appeals judges had any problem or had some deep lingering concerns about its jurisdiction. And so I think the motion is called a motion for the court to determine whether it has appellate court jurisdiction. We got a 1 or 2 sentence order back. It was per curiam, and I'm sure it's in the file at the Court of Appeals clerk's office, saying that the motion was considered and it was respectfully denied, but they didn't go into any details about why it was denied. So when we got that order back, we assumed we were still authorized to proceed. And I've raised all these issues on appeal for the court to consider. I hope that answered Your Honor's question or shed some light on it. We also felt like the court was okay with us going forward with the appeal because before the time ran for me to file a brief on behalf of the appellant, I filed a motion asking the court whether or not our brief or any portions of what we were appealing needed to be filed under seal. That was because there were previous orders placing document orders under seal. In fact, the NDA itself, which was approved by the trial judge, places the financial information attached under seal, uses that word specifically. So as an officer of the court, I felt like we were duty bound, and also because the trial judge had put the whole case under seal. I asked the Court of Appeals, does it want our brief under seal? What happened was the Court of Appeals entered an order, I think it was July 20th, 2019, remanding the entire record to the trial court for subsequent determinations as to whether orders or documents should remain under seal. We went through the procedure that the Court of Appeals established. We asked the trial court, to designate all the documents to remain under seal because there'd been a prior global consent order in November of 2015 that the parties entered into, or maybe it was December of 2015, agreeing, because the judge wanted all the documents under seal to protect the integrity of the agreement if it was upheld. The court then reversed itself. Effectively, the court sustained husband's objections and found that under the guidelines put in the Court of Appeals order that none of the documents could remain under seal, and the court ordered all previous orders sealing documents in the trial court are vacated. So we believe that the appellate court that was sending it back was of the opinion that we would be allowed to proceed and there wouldn't be a concern about jurisdiction of the Court of Appeals. Does that help answer your Honor's question? I'd like to hear you more about that issue or something else. I'm having trouble.
That's sufficient, Mr. Hellman. I still am have some lingering questions, but I won't take up your entire time with that issue.
If Your Honor, please, if there's a problem with Rule 54.02, we respectfully request that Your Honors take, at the very least, the recusal issue and resolve it under Rule 9 or Rule 2, but we ask that you take the issue of the issues that we've raised. Now, in our case, we believe that one of the issues that's never been addressed in Tennessee is the application of this expungement statute, TCA 36-4-127. This issue was raised as issue number 5. In this case, I'll be very brief. I have 1 minute and 52 seconds. We believe that that statute should have applied to this case and caused the trial court to expunge the MDA and parenting plan that had been placed before it, since it came from a prior case which was ordered expunged by agreed order pursuant to the statute. With 1 minute and 31 seconds left, I'd like to bring up the fact that we deeply ask Your Honors to review the partial recusal issue that we've raised. We believe that there's no authority in Tennessee for a judge to recuse herself or himself from one issue before him or her, or one motion, and then once that motion is sent to another judge by that judge, and some other judge decides that motion, then the case can come back to this judge, and this judge can continue ruling on the case. We believe it strongly, as we put in issue 3 in our brief, that the order that the trial judge entered, Judge Binkley, was erroneous, that when he decided on his own that Rule 2.11 of the Code of Judicial Conduct required him to recuse himself from this case for a motion, that it applied to the entire proceeding, not just the motion, and therefore it should have been recused from the entire case. There's no case that we could find, this is the case of first impression in this state, where a judge has tried to recuse himself partially and come back into the case. The Rule 10b says, no, you can't select yourself as a successor. You cannot, once you're recused from the entire proceeding. In the case of Cook v. State, which was released in August of 2020, the Supreme Court, we believe in that case, the Supreme Court made it absolutely crystal clear. Thank you, it's at 0.
Thank you. You have your rebuttal time. Mr. Hayes.
May it please the court, Larry Hayes on behalf of the appellee, Tracy Adkins, along with co-counsel Rachel Thomas. And I would start by saying that making a case confusing does not make it complicated. This is a simple case. We concluded this wife's divorce case by agreement in 2015, but she changed her mind and spent the next 5 years with a singular obsession, namely preventing that agreement from being approved. Her position is clear. She wants to stay married, and that's why she's taken the positions that she has. That's at volume 35, page 4 of this record. The court quoted that statement in its memorandum opinion on page 51. This court previously described what went on in Adkins number 1, I'll call it, 54 motions, Rambo-style litigation. But that's what she has done for 5 years. But she made the fatal mistake of lying in her attempt to bolster her case. That's one thing that we didn't talk about, or Mr. Hellman didn't talk about, is the wife's credibility. The trial court gave her no credibility. That's at Memorandum Opinion 23. And the standard is conspicuously absent from the appellant's brief. But we all know what it is. Findings of credibility are given great deference because the trial court observed the manner and demeanor of the witness. And this court, respectfully, will not reevaluate a credibility assessment absent clear and convincing evidence to the contrary. It does not exist in this record. The court, Judge Binkley, gave specific reasons for finding her not credible, both the manner she testified and the substance of her testimony. For the manner of her testimony, it found she was extremely evasive about the effect of the expungement. That's at 2957 of this record. Remember, the answer would be eggs explanation that Judge Binkley took the time to give this witness, volume 41, page 330, to try to help her, at least warn her that she's headed down the wrong road about credibility, but she didn't take the advice. He didn't believe the wife's testimony about the circumstances of the day, or the consequences of signing this MDA. That's at the record 2972. And this claim of we didn't know is pervasive throughout this whole case. But on the substance of her testimony, she denied that the terms of the MDA were almost exactly the same as the Memorandum of Understanding, Exhibit 6. But I went through each one individually and showed they're almost identical. I had her circle them. She circled 14 out of 17. That's at volume 41, page 345. And the court noted twice that the audio tape she introduced into evidence didn't match her own testimony. That's it in the record at 2955 and 2979. The court noted that her trial testimony contradicted her prior deposition testimony, page 16 of his order. And while we're discussing her deposition, they objected to the fact that her deposition is not in evidence, they say. Well, that was a calculated risk that I took under Rule 613 of the Rules of Evidence. It does not require that an inconsistent statement be made an exhibit. Otherwise, if I'm successful, as I was in this case of impeaching a witness with a prior inconsistent statement, if my opponent, in this case the wife, doesn't introduce that prior statement into evidence, that credibility finding becomes bulletproof. The wife's argument is suicidal because she's arguing that the prior statement is not inconsistent, but she didn't put it into evidence. So this court has nothing to base its determination on whether that's correct or not. So I say that she is the one who should have put it into evidence. Otherwise, that finding can't be attacked. Moving to the independent investigation that was raised regarding this USB, that's just ridiculous. By definition, an independent investigation is when a court goes outside the record. The transcript is the record. If anything, Judge Binkley did a swan dive into the record because he went to the painstaking effort to do detailed citations to the record to make, frankly, this court's jobs easier. Actually, our jobs easier. It should be applauded, that kind of effort. But this judge heard exactly the same words during the trial that he saw electronically or in writing in the transcript of the evidence. There's no error there. They were fully aware that I had sent copies of the transcript to the court on November the 10th, 2016. I sent copies because the wife, had the originals. If they had a problem with the judge viewing a copy of the transcript, they could have easily remedied that by filing the original, but they didn't see apparently a need to do that, or maybe, just maybe, they wanted to hold on to that card just in case he ruled against her, which he did. But the discussion, I would point the court to the discussion at the August 17, 2017 hearing. That shows how disingenuous the wife is in her arguments. That's volume 46, pages 17 through 26. There's a discussion there about the transcript, and they all but imply that they don't know what's on the transcript and they didn't get a copy of what was on it. That's volume 46, pages 19 through 20. In other places in this record, they simply imply the same thing. An emergency motion filed July 26, 2017. That's record 3540. They state they want access to a, quote, document that they call a trial transcript. And, quote, whatever the court used has not been furnished to wife's attorneys. In a motion to vacate filed August 2nd, 2017. I believe that's at record 3587. Paragraph 4, they refer to, quote, whatever pleading or pleadings called trial transcript from which the court drew its information in preparing its findings. This "we didn't know" business is a constant theme in this case. We didn't know what was on the USB. We didn't know you wanted a current fee affidavit. We didn't know we couldn't file 2 separate briefs in the Court of Appeals. The trial court made it very clear it was operating off a copy of the transcript. And the court also stated the wife had no credibility in arguing that she didn't know what the court was looking at. That's in the record at 4685 and 4686. And the USB leads into, sort of dovetails into this partial recusal issue. The context of that is very important. April 2016, the case is tried to conclusion. November 10th, as I stated, 2016, I sent a letter to the court with the USB with a copy of the transcript. January 2017, the court rules against the wife. March the 1st, 2017, we get an emergency motion for Judge Binkley to transmit that USB to the Court of Appeals. That's in the first supplemental record at 109. March the 7th, 2017, an order granting that motion. And Ms. Rubenstein, the judge's legal assistant, does what is tantamount to a custodial affidavit regarding this USB. That's the first supplemental record at 117. On July 25th, 2017, they issued a subpoena to Ms. Rubenstein, and that's in the record at 3660. And then August 11, 2017, they filed a motion to compel Ms. Rubenstein to testify. In paragraph 6 of that motion, they state to explain how and where pleading called trial transcript was obtained by Judge Binkley. That's it, the record at 3656. Are you serious? To explain where the pleading called trial transcript came from and how he obtained it? They've known that since November of 2016. Judge Binkley entered an order because they brought his legal secretary into this. Partial recusal, very clear. It's record 3771, cites one reason only, Ms. Rubenstein being a witness, and he states it's for one motion only. All the judges follow suit. That's at record 3773. Again, one reason, one motion. Judge Parks then picked the case up and ruled correctly that compelling Ms. Rubenstein to testify invades the judicial deliberative process privilege. That's in the record at 4091. This is not a recusal issue under Rule 10b because Judge Binkley did in fact recuse himself. It's just that he came back. The case law, Rule 10b, are both silent on partial recusals. Maybe we need a 10c, or I guess a 6th section of 10b about re-entering a case. But until then, we're basically left with persuasive authority and common sense. And both of those dictate that partial recusal should be allowed. The persuasive authority comes from Ellis, a Third Circuit case, I believe 2002. And they said it's first impression at that point. So clearly this is not a common problem. And they went with the majority view, which allows partial recusal. And then we have Decker from the Sixth Circuit, a little more recent, 2014. They also cited the majority view approves partial recusals as an important case management device. And partial recusals, they say, serves the interest of judicial economy and case management. They say partial recusal is a sound method of balancing. And I submit the balancing comes from a case such as Neal versus Hayes, where we say judges should strive to eliminate the perception of bias, even where none exists. Well, that's exactly what Judge Binkley did in this case. He was following that charge to the letter on the Ms. Rubenstein issue. I submit that the balancing is between the judicial economy and case management mentioned in Decker and the striving to eliminate the perception of bias that's discussed in Neal versus Hayes. I mean, think of judicial economy. Imagine how long it would take a new judge to come up to speed in this case. The record, just this record, it's not the entire record, just this record on appeal is 8,960 pages. So case management would be out the window. Any deadlines we had would be out the window while we waited on a judge to come up to speed. And as pointed out by the Sixth Circuit in Decker, partial recusal is a sound method of performing the balancing act that this court should explicitly approve until the Supreme Court makes it official. I would like to move briefly to attorney's fees, Judge.
Mr. Hayes, before
Yes,
you do that, obviously you've hit on a lot of issues and you've also mentioned the size of this record, but I'm going to ask you a question that's substantively about the same as what I asked Mr. Hellman. Are there issues in this case between these parties that are outstanding?
No, Your Honor. All have been resolved by Judge Binkley. The fact that they continue to pepper us with motions, he made it very clear that he was ruling on them all, he was done, and he was passing the torch to the Court of Appeals. If that's your question.
That is my question. And when did he do that? When did he conclude this entire matter, as you say, and pass the torch along?
I believe it was the last order he entered on the numerous motions that had been filed. And there was a motion to rule on motions, I even believe, and the judge entered an order that ruled on, I believe it was 10 or 12 motions in a row. It's almost like they kept filing motions trying to keep a ball in the air. And I believe he said, all the balls are down. He didn't use those exact words. That's my verbiage. But
did he use Rule 54 language attempting to make this whole divorce action final, Mr. Hayes?
I believe he did. I know he did in one part of the case. I'm not sure in that order we were just discussing if that Rule 54 language is there. I believe it is.
Well, is that appropriate? Is Rule 54 appropriate in a domestic relations matter such as this?
I think it's appropriate in any civil matter, Your Honor, to, as I say, put a period on what has been a 5-year sentence.
Well, but if the case is finally concluded, you don't have to make reference to Rule 54.
And
you
again,
make reference to Rule 54 when you're trying to make something final such that it could be appealed.
Frankly, Your Honor, I believe there was as I mentioned, the peppering, there was so much peppering of motions. He was trying to make it final if anyone had any doubt. I believe that's the intent, if you read sort of between the lines on that. I agree, it may not have been necessary to use Rule 54 language, and that order was the September 10th, 2018 order. He does cite Rule 54, and again, I think it's just sort of overkill, so he doesn't get tripped up on a technicality that, oh, you didn't resolve this particular issue. But that's just a guess.
Did he indicate that all matters then pending were resolved or denied?
I don't believe he used that verbiage, Your Honor.
Mr. Hayes, you are referring to the order where he made 14 orders final pursuant to Rule 54.02 or attempted to do so?
Yes, Your Honor. In concluding, Your Honor, since I noticed my time is running, I would simply say on the attorney's fee standard, this court, Justices Armstrong and Golden, ruled 2 years ago in Raleigh Commons versus SWH. You may remember Dr. Weinstein, that it's a subjective judgment based on the experience of the trial judge, and there's no mathematical rule or formula. And you presume that the trial court's decision is correct. And in closing, Your Honor, I would simply say the wife has intentionally delayed approval of these agreements for over 5 years. Her actions are not supported by the facts. Her actions are not supported by the law, but her actions do cry out for a definitive response from this court, and that response should be affirming Judge Binkley in all respects and awarding Mr. Adkins all of his attorney's fees incurred in the appeal of this nightmare. So thank you.
Thank you. Mr. Hellman, you have 2 minutes.
Thank you, Judge Golden. I do want to point out in response to Judge McGee's question, on page 23, I outlined the claims that we say that were never addressed, that were in Ms. Adkins' amended counterclaim. We filed a motion for default judgment on that counterclaim, and there's no valid order addressing the motion for default judgment. That's our position in the record. We believe that there are claims still pending. We want the court respectfully, though, to at least address the recusal issue. And on that issue that Mr. Hayes raised, it has been addressed. This is a state law issue, recusal. Mr. Hayes relies upon federal cases addressing a federal standard that's different. In Rule 1.04, it's real clear. A judge who recuses himself or herself, whether on the judge's own initiative or on a motion of a party, shall not participate in selecting his or her successor absent the agreement of all parties. We believe he's succeeded himself. He's selected himself, and it's highly inappropriate. It sets a standard of confusion that lowers the bar in Tennessee. Just ask this question. If the Court of Appeals, the members of the Court of Appeals were presented a brief right before argument in a case, and one of the issues that was raised in the brief relates to a person that a member of the Court of Appeals feels like she or he shouldn't decide that issue. My question is, would the Court of Appeals judge be permitted just to recuse him or herself from that one issue, but decide all the other issues in the brief? I don't believe that's the standard. I believe the case that Mr. Hayes talks about, Neal v. Hayes, Rogers v. Sallee that we have in our brief, and the other cases cited make it absolutely crystal clear that if a judge decides under that rule, like Judge Binkley did, that he must recuse himself on his own motion, he cannot come back into the case. Thank you, Your Honors. Argument 13 addresses the credibility issue that Mr. Hayes raised, and we rely upon our argument. Thank you very much this afternoon.
Thank you. We'll get you an opinion as soon as possible. Thank you very much for your argument today.
Thank you, Your Honors.
Mr. Hibner, call for the
Court is now in recess until 2 p.m.